3:12 p.m. this afternoon. Federal Judge Helen Vasquez issued a comprehensive asset freeze and power stripping order against Donald Trump. Not partial, not limited, not targeted at one account or one entity. Every business account, every trust, every holding company, every financial instrument linked to Trump or any entity in which he holds a controlling interest. Locked. All of it. Frozen by federal court order, effective immediately. This is not a fine. This is not a warning. This is not a judge expressing concern and asking for voluntary compliance. This is a federal judge looking at the evidence in front of her and concluding that a former president of the United States cannot be trusted with access to his own financial empire while this case proceeds. That has never happened before. Markets dropped 2.1% within 9 minutes of the ruling. Trump's legal team requested an emergency sidebar before the order was even formally entered into the record. White House correspondents reported staffers scrambling for phones in the West Wing hallway. 9 minutes. That's how fast the financial world processed what just happened. 5 days ago, this was a fraud case, moving at the normal pace of federal litigation. Monday was the filing. Wednesday was the hearing. Today, Friday, was the ruling that changed everything about how we understand judicial power over political figures in America. By the end of this breakdown, you'll see why this ruling is structurally different from every previous legal action against Trump, and why his own legal team's strategy is the reason it happened. Let's map this out. Monday morning, federal prosecutors walked into court with new evidence that changed the trajectory of this entire case. Over the preceding weekend, $43 million had been moved across 6 accounts in under 48 hours. Not routine transfers, not scheduled payments. Funds from accounts that had been specifically flagged in the ongoing fraud case moved to destination entities that prosecutors had never seen before. Their argument was direct. This was deliberate asset concealment in anticipation of an adverse ruling. They filed an emergency motion for a full asset freeze, something they had deliberately avoided requesting for months. They didn't want to ask for this. The weekend transfers forced their hand. Tuesday, Trump's attorneys responded. They called it prosecutorial overreach and political overreach, designed to humiliate a political opponent. They offered no explanation for the timing of the transfers. They offered no documentation showing legitimate business purpose. They just attacked the motion and dared the judge to act. Wednesday, Judge Vasquez held a closed hearing. Prosecutors presented banking records, transfer timestamps, and destination account details. Thursday, the judge requested additional documentation from 3 separate financial institutions. She got it the same day. All 3 institutions complied within hours. That's not normal. Financial institutions don't move that fast unless they understand the seriousness of the request. Friday, 3:12 p.m. She issued the most comprehensive asset restriction order ever applied to a former or sitting president in American history. 5 days. Each day, Trump's legal team had an opportunity to de-escalate, to explain, to cooperate, to offer something. Each day, they chose confrontation. That pattern is not background. That pattern is the reason the ruling reads the way it does. Judge Vasquez's order is 14 pages, not long by federal standards, but every sentence in this document carries weight. I've read it 3 times now. Page 1 establishes jurisdiction and recites the procedural history. Standard. Pages 2 through 4 lay out the factual basis, the weekend transfers, the destination accounts, the timing relative to the case calendar. This is where the judge uses the phrase conduct consistent with deliberate concealment. That is not casual language. That is a federal judge saying she is not guessing about intent. She is finding it. She looked at the evidence and concluded this was done on purpose. Pages 5 through 9 are the operative sections. Every domestic account linked to Trump or any entity in which he holds a controlling interest is frozen. Not restricted, not monitored, frozen. No withdrawals, no transfers, no new obligations. Nothing moves. Pages 10 through 12 address the business operations question. The judge appointed a financial monitor with authority to approve or deny any transaction involving Trump-linked entities above $5,000. That means Trump cannot move money without a federal officer signing off on it first. $5,000. In the context of a business empire this size, that threshold covers virtually everything. Pages 13 and 14 lay out the compliance timeline and penalties for violation. This is where the language gets sharpest. The judge included a provision stating that any attempt to circumvent this order through intermediaries, proxies, or newly created entities will be treated as criminal contempt. She anticipated the workaround before it was attempted. She built the wall before anyone tried to climb it. This ruling is not a slap on the wrist. It is a financial lockdown. And stay with me through the rest of this breakdown, because later in this video, I'm going to share something that could directly benefit you financially. Here is what Trump's legal team should have done on Monday. When prosecutors filed the emergency motion, there were two options on the table. Option 1, negotiate limited restrictions, agree to a partial freeze, offer voluntary compliance with monitoring, show the judge good faith, take the temperature down. Option 2, fight everything, call it political, refuse to acknowledge the transfers, dare the judge to act. They chose option 2. And that choice is the reason the ruling reads the way it does. Wednesday's closed hearing is where it fell apart. Trump's lead attorney argued that the weekend transfers were routine business activity and that prosecutors were manufacturing urgency to justify overreach. The problem was that prosecutors already had the banking record. They had the timestamps. They had the destination accounts. And the destinations included 2 entities that had been specifically flagged in previous filings as potential concealment vehicles. Trump's attorney was telling the judge this was routine, while prosecutors were showing her evidence it was anything but routine. The judge asked Trump's counsel directly whether they could explain the timing of the transfers relative to the case calendar. The response was that the timing was coincidental. That word, coincidental. It appears in the ruling 3 times. Each time the judge uses it, she is rejecting it. The legal team's refusal to concede anything gave the judge no middle ground. They forced a binary outcome. Either she believed everything was coincidental and routine, or she concluded the transfers were deliberate concealment and acted accordingly. She acted accordingly. This is the detail that most coverage is missing entirely. Judge Vasquez didn't just freeze the accounts. She appointed a financial monitor. His name is Raymond Alcott, former federal banking examiner. 28 years of experience reviewing complex financial structures for regulatory compliance. He has been given authority to review, approve, or deny any financial transaction involving Trump-linked entities above $5,000. Let that number sink in. $5,000. In the context of a business empire that moves millions daily, that threshold covers virtually every meaningful transaction that exists. Think about what that means operationally. Payroll for Trump Organization employees has to be approved. Vendor payments to contractors, maintenance companies, suppliers have to be approved. Loan payments on properties have to be approved. Legal fee payments to the attorneys currently fighting this case have to be approved by the federal monitor overseeing the case they are fighting. Alcott has authority to request documentation for any transaction. He has authority to delay approval pending review. He can ask questions. He can demand answers. He can say no. This is not symbolic oversight designed to look serious on paper. This is operational control over an entire business empire. Trump's businesses now function at the speed Raymond Alcott allows them to function, not faster. Financial monitors have been appointed in fraud cases before. That is not new. But typically for corporations, typically for entities with no political significance, not for a former president's personal business empire spanning hotels, golf courses, media companies, and licensing deals across multiple countries. The scope of this appointment is what makes it extraordinary. Alcott doesn't just see the books. He controls the flow. Every dollar in, every dollar out. All of it goes through him now. 40 minutes. That's how long it took. 40 minutes after the ruling dropped, Trump was on Truth Social, calling Judge Vasquez a radical activist judge and the ruling a communist-style asset seizure designed to destroy him financially before trial. That was post 1. 12 posts followed in the next 2 hours. His language escalated with each one. By post 4, he was calling the freeze unconstitutional and politically motivated. By post 8, he was calling the monitor appointment a violation of every right he has as an American citizen and suggesting he would not comply. By post 12, he was naming Judge Vasquez directly and questioning her qualifications, her motives, and her integrity. His attorneys know what this does. They have reportedly asked him multiple times to stop posting about the case. Every public statement about non-compliance gets filed by prosecutors. Every attack on the judge gets entered into the record. Every suggestion that he might defy the order becomes evidence of intent. They know this. He continues anyway. The posts from Friday evening are already cited in a supplemental filing prosecutors submitted Saturday morning. They used his own words, direct quotes from his own social media platform. They argued that the monitoring provisions are justified because the defendant has publicly expressed intent to resist the court's authority. That is not the prosecution characterizing his position. That is the prosecution quoting him verbatim. His social media is building their case in real time. Every post, every attack, every threat of non-compliance. Prosecutors are saving all of it, filing all of it, using all of it. And he keeps posting. This isn't one story anymore. It's 3, all moving simultaneously, all connected in ways most coverage is not showing you. Track 1, asset freeze enforcement. The compliance deadline is Monday at 9 a.m. Every financial institution holding Trump-linked accounts must confirm the freeze is in place. Not most institutions, not the ones that feel like cooperating. Every single one. Any institution that fails to comply faces its own contempt proceedings. The judge made that explicit in the order. Track 2, the monitor's first review cycle. Raymond Alcott begins his formal review Tuesday morning. He has authority to request a full accounting of all transactions executed in the 30 days preceding the order. That 30-day look back is critical. It covers the weekend transfers that triggered this entire sequence. If those transfers were the only suspicious movement, the look back confirms it. If they weren't, Alcott is about to find out what else moved and where it went. Track 3, congressional response. House Oversight Committee announced Saturday morning they are requesting a briefing on the ruling's implications for government contracts currently held by Trump-linked entities. If any federal contracts are affected by the freeze, that becomes a separate crisis on a separate track with separate consequences. Now watch how they connect. If Monday's compliance deadline reveals that additional funds were moved after the ruling, that triggers criminal contempt under the provision Judge Vasquez built into pages 13 and 14. If Alcott's review uncovers additional concealment in the 30-day look-back, that becomes new evidence in the underlying fraud case. If congressional review reveals government contract exposure, that opens an entirely new front that the courts aren't even addressing yet. 3 tracks, all converging, all reaching critical points within the same week. I want to give the other side a real hearing here, because that matters. A former federal prosecutor with 20 years of practice described this ruling as the most aggressive judicial intervention in a financial fraud case involving a political figure she has ever seen. She noted that the $5,000 monitoring threshold is unusually low and signals the judge has serious concerns about ongoing concealment. That is not a casual threshold. That is a judge saying, I do not trust what happens with this money if I look away. A white-collar defense attorney with experience in exactly these kinds of cases argued that the ruling will absolutely be challenged on appeal. He noted that courts generally prefer targeted restrictions over blanket freezes and that the scope of this order will be tested. But he acknowledged something important. The evidence of weekend transfers significantly weakened the defense position. Without those transfers, he said, this motion probably gets denied or narrowed. The transfers changed everything. A constitutional law professor at Columbia framed it differently. This is a separation of powers question. Can a federal judge effectively take operational control of a former president's business empire? The legal answer is yes. Courts have that authority when evidence supports it. But the political implications are enormous. And the appeal will test whether higher courts are comfortable with this level of judicial control over a political figure's finances. Here is the honest tension. The ruling is legally sound based on the evidence presented. Judge Vasquez had the banking records, the timestamps, and the destination accounts. She had a legal team that refused to explain any of it. But the scope is extraordinary. And whether it survives appeal will determine how far courts can reach when a powerful person tries to hide money during active litigation. Monday is everything. Here's the timeline. Monday, 9 a.m. compliance deadline. Every financial institution holding Trump-linked accounts must confirm the freeze is active and enforced. No exceptions, no extensions. Monday afternoon, Trump's legal team is expected to file an emergency appeal seeking to narrow or overturn the asset freeze entirely. That filing will be the first real signal of their long-term legal strategy. Tuesday, Raymond Alcott begins his formal review. He has authority to compel document production from any Trump-linked entity. Not request, compel. Wednesday, Judge Vasquez scheduled a status conference to review compliance and address any disputes that have emerged. Thursday, Alcott's preliminary findings are due to the court. Whatever he found in that 30-day look back lands on the judge's desk. Friday, if the appeal has been filed, the appellate court may issue a scheduling order that sets the pace for the next phase of this fight. Now map the decision tree. If Trump complies fully by Monday, the freeze remains in place, but the immediate crisis stabilizes. The temperature comes down. If compliance is partial or contested, prosecutors move for contempt and the temperature goes up significantly. If the appeal succeeds in narrowing the freeze, the monitor's authority may be reduced but not eliminated. Alcott stays. If the appeal fails, the full scope of the order stands and the monitor's power is confirmed for the duration. The most likely outcome based on the pattern established this week is partial compliance, contested on multiple fronts, with the appeal becoming the central battleground over the next 2 weeks. But Monday morning is when we find out which direction this moves. Monday tells us everything. This ruling matters beyond this case. Judge Vasquez just established that federal courts can freeze the entire financial life of a political figure when evidence of concealment exists. That precedent does not disappear when this case ends. Every future case involving powerful figures and hidden assets will cite this one 4-page order. The rule of law either applies equally or it doesn't. Friday's ruling says it does. Now, with everything happening in the economy right now, the uncertainty, the market volatility, the pressure that situations like this put on financial systems and on everyday people watching it unfold, I know a lot of you are feeling the squeeze personally. Costs are up, budgets are tight, and when the news cycle is dominated by stories about people moving $43 million over a weekend, it can feel like the system works for everyone except regular people. That is why I want to share something genuinely useful before we wrap up. Amazon is currently giving away $750 gift cards to eligible residents in the US, UK, Canada, and Australia. This is a real opportunity to put $750 back in your pocket, and it takes about 2 minutes to enter. If you want to claim yours, click the link on our channel page. If you are watching on your phone, tap our profile picture to go to the channel page, and you will see the link right there. A screenshot is about to appear on screen showing you exactly where to find it. If you are watching on a computer or TV, a QR code is going to pop up on screen right now. Open your phone camera, point it at the square, and tap the link that appears. That's simple. Thousands of people have already entered, and this won't last forever.